Yes, 101.1 FM, AM 1160, WCCSradio.com. Marshall Chriswell with us this morning, another installment of Martial Law. And this program is intended to be for informational purposes only. The information does not constitute legal advice. The law is constantly changing, and the information may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell is one of those people, and he's on the line with us this morning. Good morning.
Good morning.
It's good to have you with us here today. As we think about rights and obligations, people in particular in housing situations, rentals and things of that nature, one of those issues that has become more and more in the news or prevalent is the issue of service animals. And we see service animal issues with airplanes and with public transportation of some sorts, but with housing as well, correct?
Absolutely. And this has become as you said, just I've gotten more questions on this issue as time goes by. And it's something that, service, the idea of a service animal, guide dogs, and even, different animals, dogs and even horses and things that perform a particular function to assist someone with a disability. That's not a new idea. The thing that's become more prevalent is the idea of animals that are classified as emotional support animals. Mm-hmm. And so this is sort of broadened the idea of having an animal companion to assist someone with a disability, but maybe not necessarily one that is particularly trained to do something, to guide someone who is visually impaired, or to alert someone who is deaf as to a fire alarm or something like that. The emotional support animals, although they can serve a very important function for someone with a particular disability, aren't necessarily an animal that goes through specific training and things like that. So that's where there's sort of an idea of, okay, are these, is it an emotional support animal? Is it a pet? Where do you draw the line there? And what, particularly from a landlord perspective, because that's what I'm seeing a lot, is, a lot of questions about, what is a tenant's right with respect to having a service animal or an emotional support animal, and what rights does the landlord have to regulate it?
Yeah, well, there is a very big question. What is it a firm line? Is it a blurry line? Is it a movable line when it comes to, I need this animal in order to move along and to function properly in society, or I just like animals, and I like this one in particular because that provides emotional support. So that line is really difficult to establish, isn't it?
It absolutely is. It's very difficult, and what I have to caution my landlord clients on is that the way that particularly federal law as well as Pennsylvania law have evolved on this issue, it does give the tenants a lot of rights under the Federal Fair Housing Act and under the Pennsylvania laws, the Assistance in Service Animal Integrity Act. So, landlords have questions about, okay, does it matter what type of animal? If someone says, okay, I have a disability, which can be all types of disabilities, including, things like generalized anxiety and depression, or things that aren't, visible just by looking at someone or readily noticeable by interacting with them. What about different breeds and different types of animals? And the answer to that is that really any type under federal and state law, really any type of animal, any breed of animal, it can be an emotional support animal. And for purposes of landlord-tenant law, emotional support and service animals are one and the same. Under federal law, they're all classified the same way now. So As long as the animal doesn't present a concern from a health and safety standpoint, if the animal promotes if it poses a direct threat to the landlord or other tenants, or it has some sort of a health impact, it's diseased or something like that, or it disrupts the entire apartment building or something, those are legitimate reasons to deny or to possibly remove a service animal or emotional support animal. But other than that, there's really no restriction under federal or state law as to what type of animal it can be.
Well, it's interesting as well because you always deal in hypotheticals, of course, and a hypothetical would be somebody in another apartment or nearby who is sharing the same rental unit who has allergies, somebody who doesn't particularly enjoy the smells. A dog or a cat or some other animal that leaves residue, if you will.
Yep, and so does it pose a threat to the health and safety of the other tenants, and or is it such that you can make what the law calls a reasonable accommodation for the person with the disability in order to allow them to keep their service or emotional support animal. And a reasonable accommodation might be moving their apartment away from the person that's complaining of allergies, things like that. But there are some things that just within the landlord's general operation of business, if this animal is making a mess all over the place and the tenant won't get it under control, that can be a legitimate reason to remove the animal or the tenant.
As a landlord, then, Marshall, if we're designing a lease and wanting to include rights and responsibilities and protections, I'm sure there are plenty of issues that an attorney would have to handle.
Yeah, you want to be very, very careful as a landlord because if you are deemed to violate the Federal Fair Housing Act, the fines, the consequences can be very significant and very swift. A first offense can result in thousands of dollars in fines. So you want to be real careful. You want to make sure that you're not charging. If someone has a service animal or an emotional support animal, you can't charge them that pet fee that you charge to somebody else that has a pet dog or cat. You can't enforce breed restrictions. You can't say, well, your service animal, your guide dog's a German Shepherd, and I can't. And my insurance company says I can't rent to people with German Shepherds. You can't do those things. Reasonable accommodation is eliminating those barriers that someone may encounter that would prevent them from having this animal with them to assist with their disability. So you got to be real careful with those things. So if your lease has blanket policies for pets and things, you've kind of got to throw those out the window when you're dealing with a service or emotional support animal. But what the landlord can do, specifically under Pennsylvania law, this Assistance in Service Animal Integrity Act, the landlord has the right, if the person's disability is not readily ascertainable, like I was discussing, if it's an emotional or mental disability or even a physical disability that you just can't see, you do have the right, if you receive a request from someone to make an exception to a policy prohibiting animals or limitations like I'm talking about, if you get that request, you can have the person provide you documentation of their disability-related need for the animal. Now, that documentation doesn't have to be, here's all my medical records and to show you what I've got. It's very broad. It is, the law says any documentation providing that a person is disabled and requires the use of an assistance animal or service animal as a reasonable accommodation. So sometimes this is often a letter from a doctor or mental health professional, sometimes from a counselor, sometimes from a clergy member. It can be pretty broad, but there are criminal penalties to the person providing the documentation, the potential tenant, if they forge it, if they obtain a letter on the internet where somebody didn't actually examine them or see the animal or things like that. So if it's faked, there's penalties for that. And also immunity under the law for the landlord if this animal bites somebody or causes property damage.
Just a moment left this morning. I wanted to swing it around the other direction, though. What if somebody is a tenant and somebody else moves in with a service animal or some sort of emotional support animal, and they have legitimate fears of that type of animal, or they don't want to have to put up with barking and things of that nature?
So barking would be something that if it's excessive all hours, you could certainly make an argument that was so disruptive as that it doesn't allow the landlord to operate their business, in this case housing, in the way that they need to do that, and possibly a reason for eviction or removal of the animal. An unsubstantiated belief that an animal is a threat is not enough to remove an emotional support or service animal. If the next door neighbor is just scared of dogs, well, I'm sorry, perhaps the landlord can move them to another apartment, but just your own subjective fear of an animal is certainly not enough to have one of these animals removed.
A lot of issues. Marshall, if somebody wants to talk with you about it, what should they do?
You can give me a call at 724-465-5826. My office is in the R&P building at 655 Church Street in Indiana. Or you can go online to the website at www.westernpalawyer.com.
Thank you, Marshall.
Thanks, Todd. Take care.
You too.